Thank you, everyone. I will now turn on the interpretation feature. Okay. You should now see a button at the bottom to go ahead and turn on the interpretation feature. I'll let the interpreters get a moment settled into their channels. Please feel free to select into the language that you need now. Okay. Hello, everyone. Welcome to the USAID Asia Counter-Trafficking in-Person Summit from Evidence to Action, hosted by Winrock International. My name is Hermes, and I will be your technical facilitator today to ensure that you have a smooth experience with Zoom. You are at the session titled Trafficking in Persons, Prosecution, Data Questions, and Research. We will be using Zoom meetings today to enable as much interactivity as possible. We will begin in just a moment here, but before we get started, we just want to highlight a few technical features available to you today. Your participation via chat is highly encouraged, and our team will work to acknowledge and address as many comments and questions as we can throughout today's session. To help us acknowledge you and your questions and inputs, please rename yourself to your name and organization by clicking the participants button at the bottom of the Zoom window, hovering your mouse over your name, clicking more, and then rename. The meeting today will be recorded for your information. Please keep your camera off unless you are invited to speak in order to help everyone have a smooth connection today. Continue the conversation in the conference community on MS Teams and spark further conversation on social media using the hashtags WinrockE2A and hashtag Evidence to Action. Once again, you are at the session titled Trafficking in Persons, Prosecution, Data, Questions, and Research. We are now ready to get started, and I'm going to hand the floor to Archana Kotecha, CEO and founder at the Remedy Project. Archana, the floor is yours.
Thank you, Hermes. And thank you to USAID and to Winrock International for inviting me to be here and to have this very timely conversation with our esteemed panelists. For those of you who don't know me, my name's Archana Kotecha, and until as of 10 days ago, I was the Asia Region Director and Head of Legal of Liberty Shared, and some of you may have known me in that capacity. I guess, you know, I spent the last 7 years with Liberty Shared working on a whole range of issues, cases, policy, legislation, etc. And where a few months ago, it left me thinking in a slightly dissatisfied position over, are we doing the best that we can? And I guess the onset of COVID really triggered a lot of questions in my mind over, was I in the best capacity that I could be? And in fact, were the solutions that we were providing the best solutions really? From a human rights lawyer's perspective, I was looking at, judicial mechanisms that we have used time and time again at the criminal justice process, at the way victims engage with this process. And I felt very much that there was a lot more that we could do because prosecutions were not going to provide the answers on their own, and that the criminal justice process needed complementarity to a degree. So I left 10 days ago and I set up what is now the Remedy Project. I don't promise any answers with the Remedy Project, but it will certainly be a journey of exploration of smart mix of solutions, most likely non-judicial, to help complement a lot of the judicial mechanisms that currently exist. I think there is a need to demonstrate a bit of creativity around the way we find solutions to problems that are presented, for example, in global supply chains, and a lot of issues such as systemic coercion that may not have been contemplated at the time the Palermo Protocol was drafted. So that's my attempt with the Remedy Project, a social enterprise, to really explore a different mix of solutions that might be made available to vulnerable people in order to make Remedy more accessible to everyone. It's a big dream, but I've been taught to dream big. So there we go. And I'm really pleased to be joined by my esteemed panelists today, very well-respected practitioners, and I'm sure most of you know them very well. But nevertheless, I will turn to each one of them to briefly introduce themselves. Mark, over to you. Unmute yourself, please.
Sorry. Thank you, Archana, and good morning, afternoon, and evening to everybody. I'm Mark Taylor. I'm currently an independent consultant on trafficking matters based in Chiang Mai, Thailand. I started in this, working on this issue back in the late 1990s. And my most notable experiences have been as the senior coordinator of the U.S. State Department's Trafficking in Persons Office on reports and political affairs. So basically leading the team that produces the U.S. TIP report on an annual basis. Later, the team leader of the Australia-Asia program to combat trafficking in persons, which was the previous version of what's now ASEAN Australia program to combat trafficking, and most recently as a technical advisor to the Global Fund to End Modern Slavery.
Thank you, Mark. Darlene?
Thank you very much, Archana. A pleasant day or evening to everyone. It is an honor to join this esteemed panel. So thank you for having me. I am Darlene Pajarito, currently the Justice Systems Director of ASEAN Australia Counter Trafficking. This program is a 10-year investment with an overarching goal to promote effective justice systems within ASEAN that provide just punishment of traffickers and protect the human rights of victims. As Justice System Director, I provide technical advice or assistance to the 7 ASEAN member states, particularly Cambodia, Indonesia, Laos, PDR, Myanmar, Philippines, and Thailand and Vietnam in the criminal justice area with focus on victim protection. The program, before my stint with the ASEAN Act, I was a prosecutor for the last 15 years with experience in investigating and prosecuting human trafficking cases, as well as formulating and implementing anti-trafficking policies and initiatives, having served as the Executive Director of the Philippine Interagency Council Against Trafficking from 2015 to 2018. So looking forward to this discussion today. Thank you.
Thank you, Darlene. Andrew?
Thank you very much, and it's wonderful to meet everyone this morning. My name is Andrew Watsawong, and I'm the Director of International Justice Missions Office in Thailand, based in Bangkok. I've worked for IJM for about 10 years, with 4 of those years here in Bangkok. Our work in Thailand is focused on combating forced labor and forced labor trafficking in Thailand, with a specific focus over the past couple of years on the fishing and seafood industries. Our work approach is to work closely to provide support individually to survivors of trafficking and forced labor, and to work closely with police, prosecutors, and social welfare officers as the case progresses through the system, in making sure that we can advocate for and protect survivors as they go through that process as much as possible and achieve just and effective and efficient outcomes. Before working for IJM in Bangkok, I worked for IJM's head office in Washington, DC as a senior program manager for Southeast Asia, supporting IJM's program design, monitoring, and evaluation of our programs in Thailand, Cambodia, and the Philippines. So thank you very much. Good to see you this morning.
Thank you, Andrew. And so the topic of our panel today really is trafficking in persons, prosecution, data questions, and research. And, you know, it is also very interesting to talk about this topic right now, because the outgoing special rapporteur put out a report where she called for a more socially inclusive approach and a more rights-based approach, as opposed to a law enforcement approach towards interpreting the Palermo Protocol and existing jurisprudence. So it makes it a lot more interesting today to really go into the data sets that exist around prosecutions, and to look at how outcomes are measured, and perhaps what areas of research are there that one could really delve into in order to really improve understanding of whether these are really effective or not. So I want to start off with Mark. And Mark, could you perhaps help set the scene around existing data sets and prosecution profiles, and in particular how research in the tip sector is happening? So do we need to redouble efforts in this area, or do we need to shift away and look at a different paradigm?
Well, thank you, Archana. That seems to be the question of the moment. Maybe if I could start with the very briefest of background on the current landscape. So prosecution measures have largely been measured on a quantitative basis. And one of the more prominent tools used is the US TIP report, which of course I'm familiar with. I think others are as well. There's the UN ODC Global Report on Human Trafficking. I've sent you a link because I didn't want to throw slides up on the front here, but if you can refer to it. Basically, it shows how slow progress has been in the 20 years since Palermo in achieving meaningful prosecutions around the world, and I've put in the Asia figures given the relevance of that, and that's Pan-Asia. from South Central all the way to Pacific, but you see roughly 11,000 prosecutions a year versus a problem of what the ILO and Walk Free tell us is 40 million. So that's something like 0.02% in terms of ratio of prosecutions to victims. That number also seems to be slowing, even stalling in some places. The current JTIP ambassador, the Trafficking in Persons ambassador in the United States, made a great statement earlier this year. He said, one is more likely to be hit by lightning than prosecuted for a human trafficking crime. And I think that's been echoed by others like UNODC, who pointed out in their global report in 2016 that the absence of this kind of robust criminal justice response really makes it low risk and very high profit. And so until we see some more significant improvements, that's the way it's going to be. Why? Now those reasons are many, and I don't think we have the time to go into all of them, but very briefly, law enforcement characterizes human trafficking as very difficult compared to other serious crimes, often because of the human element, the need to have a survivor, a victim to be a witness, and an effective prosecution. Also, the fact that law enforcement tends to approach this problem as it does all others in a reactive mode, yet we know human trafficking is a hidden crime and one in which its victims seldom self-report to frontline responders. In this region, I don't want to be overly negative, in this region, and I've worked on criminal justice issues here, we've seen progress, clear progress, and the beginnings of some good practices that are taking root, things like having dedicated investigative units, having dedicated courts, having trauma-informed frontline responders that are dealing with victims, and having victim witness coordinators who help walk survivors through the legal process if they so choose to go that route. But there's also some very tough outliers. And this is what's the largest problem, is that the larger criminal justice system in some countries is fundamentally broken, or at least it's not delivering justice to most of its citizenry. And to put pressure on those governments, on those states to make a special effort on human trafficking that is victim-centered, is trauma-informed, is sometimes a bridge too far. At least it won't achieve long, significant gains. So if I could use a metaphor of squeezing oranges to make juice, I think that in those kind of situations where you have a fundamentally flawed justice system, we're not going to get much more juice out of squeezing those oranges. That said, though, there are other areas, other countries where things are promising and where there can be successes that can be built on. Switching to research, just as I started saying, most of the research on the criminal justice approach of prosecution has been rather basic to date. It has been rather quantitative, listing off the numbers of investigations, prosecutions, convictions, and disaggregating them a bit, but not very far. There's been some qualitative work that's impressive and growing, but it's been mainly centered in the United States and Europe. In this region, there hasn't been so much of that. Now, there are reasons, there are clear barriers to doing that kind of research. Justice agencies, actors are not very approachable sometimes. Data is often jealously guarded and not shared. And writing or publicizing research that is dealing with this can be sometimes sensitive to governments and the ability of researchers and organizations to function in those kind of countries. Taking this to, getting back to Archana's key question though on bringing this together, I think that the future on this topic really needs to be a smart balance between capturing those practices in the criminal justice system that are taking root and building on them, and clearly There are some success stories. There are some survivors who speak well of their criminal justice experience, but also looking at alternatives of getting, looking further afield, because we know that in some cases, this criminal justice approach is just not going to work. Like I mentioned, the countries where there are fundamental problems with the justice system, also there are formats of trafficking that make it very difficult intrinsically for the criminal justice system to attack. And that in particular is the area of labor trafficking involving corporate entities who cannot be prosecuted criminally in some countries, and who really are part of a more systemic, institutionalized coercion, as Archana referred to, and therefore it makes it more difficult to find that particular nexus or criminal point for prosecution. So
thank you.
That's
That's so good to get us started, Mark. Thank you so much. And I think one of the things that I've observed as a practitioner over the years, as I'm sure you have as well, is the difficulties and the intricacies between systems of victim identification and the pressure to actually identify only if you are going to possibly get a successful prosecution at the end of the identification. So the impact of the pressure to prosecute successfully and to achieve that outcome actually filters all the way through the processes, sort of almost if you work backwards from the identification, even prior to the identification. And we see that, a lot of things, for example, where you have a period of 24 hours or 7 days to identify a victim, and the pressures that puts on not just the victim, but the system itself, in order to have a positive criminal justice outcome, which is essentially a successful prosecution. For example, needing victims to collaborate with authorities in order to be identified and to be referred onward for services is just another example of how the pressure to achieve these criminal justice outcomes actually taints the way people are treated, all the way from the time they are potentially rescued to the time they exit the criminal justice process. So, Andrew, turning to you, are the right outcomes being measured, and are these being measured in a nuanced way enough, or do we need to do these differently?
Thanks, Archana. So my response is yes and no. Great response. Let me start with the big picture. So the result that we're all working for and we want to see is decreased trafficking, decreased victimization, better systems, and increased community protection. Law enforcement and prosecution is not the only tool in a counter-trafficking response, but it is an important tool. It is very important, however, to connect law enforcement and prosecution data and outcomes to actual improvements in community protection and to survivor experience throughout the process. At IJM, we attempt to do this through quantitative crime prevalence studies, as well as qualitative criminal justice performance baseline and endline studies, which are available up on our website at ijm.org/studies, if anyone wants to take a look at those. And we tried to measure how has effective or ineffective law enforcement had an effect on decreasing quantitatively the prevalence of victimization to trafficking in specific areas. We also look at how has that government and justice system responded at the beginning and then later, were there changes? And just to make the point before moving on, in our experience, what is crucial to effective and good prosecution is actually counterintuitive. It's not the expertness of prosecutors, although of course that's important. It is really how does the system treat survivors along the way? Is survivor well-being given center stage? Does government social services collaborate well in a country with police and prosecutors? How well are communities and NGOs allowed to be engaged in the process? And strong law enforcement only works when it's done this way. I think one gap in measurement is the focus just simply on conviction numbers, which while important is obviously not enough. I think we really need to look at what is going on underneath the hood. So what is the quality of the process and the system that went into that prosecution? What is not being measured enough or in not a nuanced enough way? I think are again indicators around victim experience throughout the process, which I know Darlene will speak more towards. So back to measurements. I think I'd like to frame the additional nuance needed around prosecution measurements in three areas: results, community stakeholder confidence in the system, and can survivors or victims actually rely on that system to help them. So for results, that's obviously the most basic measurement. Are effective prosecutions, are results from that being achieved, and are they being achieved in the right way, meaning with trauma-informed and victim-centric processes. And I think that's where more nuanced measures are needed. We also need to measure quality, not just the end result. What is quality? What's underneath the hood? So have those results been achieved in a timely manner? How long did it take to go through the system? What about delays? Delays are bad for the system and bad for survivors, but it's easy to measure. Where do those delays happen in the system? Are the results appropriate? Was the sentencing commensurate with the crime, or is the result of a justice process essentially still continued impunity for traffickers? What about survivor experience? How many times have survivors been formally interviewed in order to make the process effective? We know that victim identification is onerous in many countries. So what is the rate of identification versus rejection? What are the reasons that go into the decisions made by those frontline responders to identify or not identify? And that helps us really zero in on tactically what's going wrong here. What % of survivors were informed of their rights and options by the government at the beginning of the process versus being not given a real choice at participation in the system? So these are all indicators that we're trying to measure at a granular level in our IJM programs. To wrap up, for community and stakeholder confidence in the system, and can survivors or victims actually rely on a system to protect them? I think this is also where we need more qualitative research and measures. For example, can be done through stakeholder or community surveys by seeing what the public thinks of the justice system overall, or with a more focus on survivors or those that work for or with survivors. We can get a sense of what are those problems that remain in the system, and have that research and information to help us hold that system to account. Because if we're not measuring these things, if we're not measuring public and survivor voices, we're not able to hold that system to a higher standard. And then for reliance, ultimately, and this is probably a long way off for many of us in our projects, what we want is a system that actually works, right? Like there's supposed to be a system. In most cases, the system is broken. And I think we all agree we need a holistic response, and the prosecution and justice system is one important part, but not every part. But when it comes to that specific system, we want it where it's working good enough that people can go to it and expect a good outcome without too much outside support. So again, that is a long way off, but we are building into it, I think, to make sure that trauma-informed and victim-centric practices are included in the prosecution process. One last point is that I think also useful are system-level measures when we come to thinking about a system itself. So actually in my work, we've found government officers in police, we've found prosecutors and social welfare officers that are good people, and they want to do the right thing, and they understand the problems in the system and they want to fix them. But bureaucracy and changing bureaucracy is hard. I had one officer say, the bureaucracy is killing me. So I think it's important to measure system level things such as infrastructure, policies, staffing levels, the financial capacity or budget of those agencies, transparency around how is that budget being used effectively. All of these things are also very important to understand the environment in which prosecutions happen, and ultimately the effectiveness of a system to keep going forward. So that's a high level. Thank you.
Thank you, Andrew. I mean, you know, what I took away from what you just said was the need for really looking under the hood and the need for qualitative research. I think one of the areas where this is really salient for me as a practitioner is when you look at the issue of compensation for victims and the difficulties with actually enforcing those compensation orders. there rarely seems to be any kind of holistic approach towards prosecution that marries the financial approach, looking at where the monies and where the assets are, with actually pursuing the criminal offense itself. And therefore that results in a victim potentially being awarded something, at the end of a trial and not being able to enforce it because the assets and the money are all gone. So one really questions, what kind of justice was this, and justice for who? And that's why the qualitative research is so important, because it really does highlight where the gaps are and what more could be done to address some of these significant challenges. So, turning over to Darlene. Darlene, we've all, there's a common theme emerging here about a paradigm shift, the need to be a lot more rights-based in terms of the approach we take. And investigations and prosecutions are often notoriously screwed towards achieving criminal justice outcomes. So how does this impact victims, particularly where they are compelled to collaborate with this process?
Sorry, I was on mute. Thank you, Archana. I was listening to Mark and Andrew and looking at the data shared by Mark. We could see that there is a link, or whether or not there is a link to impunity and convictions. As the numbers of, as mentioned, that as one of the parameters of success is really looking at the criminal justice outcomes, and one of those parameters of the success they're looking at is the convictions. I wouldn't say a total paradigm shift, because I think there's already been a shift if we compare today and maybe 10 years back. And even Andrew was saying that there are really good state actors out there who are actually aware, but we need more focused on value of victim-centered investigation and prosecution, and put out as an index the victim protection outcomes as well as one of the parameters of success, so that we won't be limited at looking at just the conviction numbers. So successful investigation and prosecution is not just about securing a conviction for justice to be served. From the lens of the victims, they may not see justice in the same perspective as state actors do. So in some instances, for example, justice for victims can be just having access to an interpreter. And if that is not provided, then actually that stops the process from them to actually secure justice. That's just one basic example. So this is the fundamental reasons why providing assistance and protection to victims is not conditional to victims participating in the criminal justice process, criminal justice system processes. It is really important to recognize the rights of victims at the onset and respect their informed decisions once they make them. The international and regional frameworks and even domestic laws in many jurisdictions provides for victim protection clauses. So the gaps, however, lies in the weak implementation of these frameworks and awareness that victims cannot be compelled to participate in the justice processes, and understanding the reasons behind their non-cooperativeness. And we have heard a lot of complaints and challenges for the justice state actors on victim cooperativeness, and this remains a global issue. And parallel to this challenge is the lack of limited knowledge and capacity and skills, and even in leadership to influence and bring about the necessary change in policy and even in behavior to ensure balance of interest and consistency in applying the right approach in handling victims of trafficking and forwarding the best interests of the victims rather than that of the state and non-state actors. So for those victims who do participate at any level in the criminal justice process, it is crucial for state actors to be capacitated to respond appropriately in the presence of and towards victims of trafficking. So there are several responses, like looking at best interest or approaches and strategies. We're looking at the best interest approach or right-based approach. Looking at, Andrew mentioned about trauma-informed approach and the victim and gender-sensitive approach when we are handling or responding to victims of trafficking.
Thanks, Darlene. I think one of the problems with the criminal justice process, to steal a phrase from Simon Sinek, is very much that we see it as a finite game. There is an end to it. The point is, for victims and for survivors, this is not a finite game. This continues afterwards. So therefore, it really requires one to look beyond the criminal justice process and to really look at socially inclusive processes that look at rehabilitation as much as they look at, what value does the criminal justice process bring to fixing the harm that has been done. And I think this is one of the high points also highlighted by the UN Special Rapporteur in her report, to really talk about a more comprehensive approach towards victim protection. I think the other problematic issue is victim consent. How can you genuinely say somebody has consented of free will when they're placed in a situation where they face repatriation unless they collaborate with the authorities? Mm-hmm. And it is a very problematic situation, and I think we really need to work on addressing the consent issues in order to ensure that if there is engagement with the criminal justice process, that it is well-founded and it is real. So just shifting back to Mark again. I mean, Mark, there are clearly some significant gaps in the efforts that are taking place currently on the ground. And acknowledging that there is, of course, a lot of good work that is also being done. But the gaps also impact the sort of the understanding that we have and the data sets and the research that is out there in relation to these issues. And I'm thinking in particular about labor trafficking and the systemic coercion issues there. Could you perhaps speak to some of that, please?
Sure. I talked about the general deficiency on prosecution performance. Looking at labor trafficking, it's even within the context of global prosecutions, it's disproportionately poor. It's 10% or less of all prosecutions. Yet, as we know, it's the dominant form of exploitation. ILO puts it at 64% of all forced labor in the world, and in Asia, it's certainly at that level, if not higher. This is a problem that we see in terms of performance, and that has also been seen in terms of research. While there's plenty of good research, and the body is growing daily on causal factors, on vulnerabilities, on experiences of labor trafficking survivors, victims, such as those that are crossing borders here in Southeast Asia, there is almost nothing on the criminal justice system response to labor trafficking, particularly on the qualitative side, on what victims are experiencing when they come into contact with criminal justice actors like immigration officers, average police, court systems, and social workers. So I think that that's an area where, and this already overlaps with some of the earlier comments from my colleagues, but where we really have a gap and need to see more done. Particularly, as I mentioned, looking at, what are the toughest cases for the criminal justice system to handle? Where is it probably not worth our investment of resources that are quite finite in engaging criminal justice? This trafficking within large corporations, trafficking that's started by systemic coercion in recruitment. Is this something that's more appropriately addressed by an alternative mechanism like a civil suit or a labor tribunal or a private sector-led initiative like the Remedy Project? So I think that the labor trafficking still is not getting its fair share by any means. Sex trafficking still dominates the discourse. And as far as criminal justice goes, it's, and this may not be fair for Asia, but globally it still dominates research.
It's interesting, and thank you for those remarks. I think when it comes to corporate accountability and sort of really looking at using prosecutorial efforts against corporations, sometimes the problem is that they're not recognized as legal persons under the law, and therefore you can't go after them. And then the second thing is the asymmetry of power between corporations and, migrant workers or, NGOs that might be going up against them in court. And the reality of that really is a procedural nightmare, but also you're outmatched in terms of resources. And also, remembering that in Southeast Asia, many countries have criminal defamation laws that are used very prolifically by corporations against workers or human rights defenders in order to deter them from actually bringing cases forward. So, this really is an area where, that warrants a lot closer attention, because it's one thing having a lot of laws that address corporate transparency where companies have to make disclosures. It's quite another thing to be able to have accountability. So the stick that goes with a carrot, essentially. Andrew, I just want to come back to you for a moment. Mark touched on, potentially the role of the private sector in providing some solutions. Could you perhaps offer some thoughts around the systemic contribution of NGOs, particularly in relation to prosecution efforts and data sets as well?
Yes, thanks. I think actually there's a lot that NGOs can contribute to this. We're just not always organized together to focus on it. And then, as Mark mentioned earlier, data and information we get working on cases or engaging the government is often sensitive. And so then it's just some real practical challenges about how do we share knowledge and information. I think NGOs can directly contribute actually to prosecution efforts and data sets. Many NGOs are engaged in the system, either legally or as victim support to victims that are coming out of a situation. So for example, with IJM and our approach, we call it collaborative casework. And as I mentioned, we partner with police, prosecutors, and social welfare officers, and providing direct support to survivors through the system. And so when it comes to a legal case of prosecution, it essentially could look like providing a prosecutor who is overworked with a high caseload or lacks specialization or resources to be able to have, for example, private lawyers from NGOs that are specialized together with victim witness support that Mark mentioned about, or victim advocates or aftercare specialists that can make sure that these survivors are supported and fought for and protected, and can stand in the gap a little bit when the justice system is not treating them the way it should yet. I think as a result, by engaging in a legal process and fighting to protect those survivors, it gives NGOs a very clear diagnosis function. So the closer an NGO is involved in a legal case, we see where those gaps are, right? We see where the system failed the victim. We see where things are slow. And that helps us diagnose what's the problem. That can then be data that feeds into policy work, maybe together with a group of NGOs that are saying, these are the things that we are seeing, and we raise our voices together and advocate for the government to fix those things, or advocate with the public to be aware of those things. And then resourcing, training can come out of that. So I think there is a lot of, again, granular level detail that NGOs see, which is really important, because sometimes it is at that level that the system's not working, and it's hard for many people to see down to that level. So I think that's an important data piece that NGOs can contribute. And maybe perhaps in the Q&A, I'd love to hear perspectives from others working in the NGO sector on how could we better pull ourselves together to advocate, to make the impact we want to see together.
Thank you, Andrew. I mean, Darlene, my next question was to you really about victim experiences. So I'm just going to look into the chat very quickly. There's some questions around that. So if we could perhaps take Chum Bali's question. Tip victims do not want to cooperate with law enforcers for court processing because they have many reasons. They don't trust the justice system. They might be charged with defamation. Suspects might be their relatives. My question is, how can we encourage victims to participate with the court process? And you'll forgive me, but I'm going to double the second question on that to you, Darlene, which is, what is the potential of developing prosecution efforts by learning from victims' experiences?
Thank you, Archana, and thank you for that excellent question. I think there's a huge potential in enhancing the capacities of prosecution efforts. A lot of insights can be actually drawn from the experiences of witnesses who went through the criminal justice processes. Um, well, I can do share some one example. It was not really a research, but a project that was conducted by the predecessor program of ASI and ACT. It was during the active time when we piloted a project of victim witness coordinator, having a victim witness coordinator. Although this person might be a support person for the prosecution, because he had to coordinate with the victims before the victim actually talked to the prosecutor. But this victim witness coordinator's role is really also a good support person for the victims, because this person actually would really assist and look into the needs of the victims, anything from the victim that may be experiencing like threats or doubts, or even some intimidation from external factors and pressures, whether that be from the family, community, or even from the defense side. No? But after I think it was piloted and placed together with the anti-trafficking task forces in the Philippines, but the victim witness coordinator was more than just a support person. That the coordinator actually was viewed as a friend by the victims who had experienced or encountered having a victim witness coordinator be with them during the entire process. So, and when there was an impact assessment made after that, and the positive result there was that a big percentage, or 90% of the victims actually said that they wouldn't have participated in the criminal justice process had it not been for the assistance that was provided by the victim witness coordinator. So the takeaway there was really the value of putting in the forefront the needs and the assistance that the victims really focus on the victims, rather than really just looking at the evidence, but really the basic needs, and including just basic as having an identification card, because most of the victims didn't have an ID. So that prevents them from even accessing other services that they are entitled to under the laws. But so the victim witness coordinator even extended their assistance to just helping them filling up forms and getting all the necessary things just to get through that process. So as simple as that. So that really helped empower them, and the coordinator also informed them of the status of the case from the onset up to where they are now. So making them understand the value of their participation in the process, and that they're not just another witness or just a number in a case. So giving them value that they are very important in the process would actually, well, based on the assessment made, would actually contribute to their cooperativeness in the process, that they're not just a witness that the prosecutor need, or that required in the system, but they are a valuable person, and that what they feel and what they need is just as important. So I think that would really be important uh, information for the prosecution, and even for the other state actors to understand and appreciate, and I think that can help curb cooperativeness of any victims. But then, of course, we always have to respect their decision, but it has to be an informed decision, them knowing everything in the process, and that they will make that decision. As you have mentioned, that the value of consent in everything that is being done. Don't shove down their throat that this is important, that they need to do this, but really to explain the process and let them decide whether or not they want to participate in that.
Thanks, Darlene. And it's very interesting. I think judges are also a very important part of all these prosecutions. And I think judges, particularly those who have inquisitorial powers, don't use them enough to ensure that they are able to understand everything they need to understand about victim psyche or victim's case. For example, they're very reluctant to call an expert themselves because they might appear to be biased in favor of the victim. I've experienced that firsthand, and they would quite candidly say that they don't feel comfortable doing that. So there are a lot of factors in addition that go beyond the victim themselves and the prosecutors that can help to actually make the system a lot better. There's a question here from Shinyi, which I'd like to address to Mark, please. So this is more a meta question or corporate accountability. Would strengthening the stick weaken the carrot in terms of ensuring transparency in supply chains and uncovering issues and incentivizing remediation? How do we balance the two? Would a no-fault compensation system be better?
Oh, that is a great question. I think since the Ruggie principles came out, there's obviously we're seeing more private sector initiatives on remediation, things like reimbursement for recruitment fees. And right now, the stick is not very strong. I think the way of strengthening the stick without necessarily killing the carrot or pulling it away completely might be in something like the Remedy Project, I think, envisions something that's more addressing a system and a set of guidelines that a wide group of parties, recruiters, employers, suppliers can sign on to and stick with, increasing the accountability, increasing transparency, and therefore being more meaningful, but yet still showing that there's benefits for the owners of that supply chain, those who invested in the supply chain to participate. Not so sure that a no-fault compensation system would really work. This, I think, is where we really, to me, that just shines light on the need for the victim experience data. Is what do victims really want? Do they want a no fault? I mean, is that the priority, is to get compensation over an issue of accountability or fault? For example, an apology or a formal acknowledgement of wrongs committed, or is that is that very much important to them?
Thanks, Mark. And I think that the breadth of remedies available within the judicial system is quite limited. And when you step outside and you look at localized solutions such as alternative dispute resolution, the breadth is much wider. If you think about the UN guiding principles and the whole spectrum of remedies that are available within that context, that could actually very well be adopted by the private sector. And just to finish off on this, I mean, one of the important changes that's happening across the world, which will impact Southeast Asia, and which will impact how justice solutions are developed in supply chains in particular, is the fact that you have mandatory human rights due diligence laws coming in Europe in 2021. And much of the modern slavery legislation that is popping up across the world now has a lot more teeth than the UK's Modern Slavery Act. So it will inevitably put a lot of pressure on supply chains that are based in Southeast Asia and push, actors such as the private sector and various others to be a lot more proactive in finding solutions. And I think that will really add value and also support, to a degree, the existing judicial mechanisms. So there was one question from Sally earlier, if I can get back to there very quickly, about any research. Andrew, are you aware of any research that's been done around remedial justice, in particular compensation or restitution across Asia or Southeast Asia?
The quick answer is I'm not familiar with research that exists to that. Mark, any ideas?
I think I can think of is didn't Impact do a study on remediation of workers in the Thai seafood industry?
Could be.
I think they did that on the big Thai company, but can't think of a lot.
Okay, so Darlene, there are a couple of questions addressed to you specifically on the victim witness coordinator, but I'll let you answer that in the chat so that it doesn't take up our last few minutes. But I wanted to go back to Mark for a moment. what, in your opinion, should be the key parameters to measure outcomes?
The key parameters to measure outcomes, really what's been lacking is the satisfaction really of survivors. And that's something that's, as I mentioned earlier, is being measured already in other places in the world. A study that came out 2 years ago in the US found that less than a quarter of survivors who are in the criminal justice system or did not want to participate in that or did not have a satisfactory outcome. So I think that's something that we need to start looking at more. The term victim-centric is used by everybody now, I think, in this region. It's mouthed, but what does that really mean? And how do we can measure that in terms of survivors' own statements, own experiences, and so they need to start rating their outcomes when they've hit the criminal justice system, and at the same time, those who are using other forms of redress, which are not many, and that's a trickle but growing, how they're faring. So getting that kind of third-party analysis.
Thank you, Mark. Andrew, can I ask you the same question, and perhaps you could also throw in, what from your perspective are two key gaps that need to be addressed in terms of the research?
I think similar to what I said earlier and what we've been talking about, gaps are the quality of prosecutions, what's underneath the hood, all of those things. I think more data into that needs to come out, and more coordinated information sharing amongst NGOs so that we can join our experience and voices together and bring that weight of that to government for a change. Also, of course, about the experience of victims. And I agree that labor trafficking is a major gap, as Mark has pointed out. I think the statistics was something like 16 million people in slavery today for labor exploitation versus 55 million for sexual exploitation. I think that's GSI data. And the most recent TIP report noted labor slavery cases are about only 8% of those reported by governments for the TIP report. So I think that is a clear data gap as well.
Thank you. Darlene, can I ask you the same question?
Sorry, Archana, can you repeat the question, please?
Yeah, sure. So what do you think are two key gaps when it comes to research in this area?
All right, thank you. Well, one of the key gaps in existing data sets in the information is the information on victim protection outcomes. I think we don't see a lot of that, and how this can influence state actors and non-state actors to balance their interests and that of the victims when working with victims. Outcomes on victim protection are not indexed as like other criminal justice outcomes. So this is probably due to some confidentiality issues, but I think this can be done without compromising the confidentiality rules covering victims of trafficking. As I've mentioned, the VWC project is one clear example where we look at the positive outcomes in the behavior of the victims and why they participated in the criminal justice processes. So another gap in information is what the outcomes are as far as the victims are concerned after conviction is secured. And I think you've also mentioned that a lot of the decisions we have are just paper decisions, and we don't see victims actually getting the compensation or civil claims, even if they are awarded by the courts. So the gap there is really relevant information, victimless. And also, if I may add one more, well, we need more, well, I guess some efforts on how we can do victimless prosecution to at least minimize, if not eliminate re-traumatization or victimization of victims when they go through the criminal justice process, and how we can support and develop evidence-based cases over victim-based cases.
Thank you. Thanks, Darlene. I think that's a really good point. And I think, a lot of it, particularly when we do a lot of work around financial flows of monies relating to trafficking, that is a really good and compelling way of supporting the case of victims by taking pressure off them as well. And there's a very good question from Natasha, which will be the last question that I will put to you today. So what is missing for the State Department to move to another benchmark to measure success? And how can NGOs and institutions doing work in this sector best advocate for this shift away from prosecution, or at least not making it the only benchmark? So Mark, maybe I'll go to you first.
Sure. Yeah, the TIP report is clearly too heavy on criminal justice indicators, and the minimum standards that the report has to use per the trafficking law in the US, they need to be revised. They've been tinkered with every time there's a reauthorization of that law, but not substantially away from these like 80% focus on criminal justice. What they basically, it needs to go to add in some qualitative indicators, and that's going to require some heavy thinking and the bringing together of stakeholders. But this is a perfect time, given the political transition in the United States. There's new thinking on everything, and I think it's a perfect time to look at this issue as the U.S. reestablishes its leadership on human rights issues like trafficking in persons.
Thanks, Mark. Andrew?
I'd agree with Mark's emphasis on qualitative. I think often, for example, I've heard from government partners that, well, if we're doing a good job, the number of prosecutions should be going down, shouldn't it? Because there's decreased crime. And that's often kind of a cover that some governments can use, but there's a degree of logic to it. And it seems like one of those things the TIP report is always looking for is an increase in the number of prosecutions and convictions. Without any ascertainment of quality underneath that, it becomes a little bit meaningless. So I really think that is needed. I'd argue that we shouldn't perhaps step away or do less of that focus on prosecutions, because as Mark pointed out, the number of victims identified compared to prosecutions that are happening is way out of balance. But I really do think we need to give a hard look at what's underneath that and the quality.
Thank you. Darlene, just very briefly, do you have any thoughts on how NGOs and institutions working in this area can advocate for shift away from prosecution or not making it the only benchmark?
Yes, I think the NGO are in a very good position to advocate or help support the state and other state actors to look at or providing support into giving more focus on the implementation of the Palermo Protocol, and for in the ASEAN region, be active and looking at or giving more focus to the objective of the implementation of active victim protection is concerned, and that includes really supporting, enhancing the capacities. Not only, I'm not talking just about training, but really enhancing their capacities into being more socially inclusive and being able to balance the interests of both the state and the Pacific.
Thank you so much. And, I guess, just to wrap up, we're pretty much out of time. A lot of what we heard today was about refocusing the priorities around a victim-centered approach, and to really align sort of, the sort of prosecution outcomes in a sense with taking a rights-based approach more than anything else. We also heard about, the need for a more holistic approach towards looking at the different components of a prosecution and about how intricately linked so many processes are, for example, victim identification, et cetera, that become very contingent on the criminal justice outcome. We heard from Andrew about the need to really look underneath the hood, the need for qualitative research to really understand what is the quality of prosecutions we're looking at, what it is that NGOs are bringing to the table, how are these numbers impacting community protection, and almost every speaker spoke about survivor satisfaction. How do they feel going through the system? What are their perceptions? What can we learn from them in order to improve this system? Mark spoke about the gap around labor trafficking, a very compelling issue, and the really important to find a smart mix of solutions that would really go towards addressing some of the issues we have around access to remedy, and that could really bolster access to justice for a lot of vulnerable people. And Darlene spoke so compellingly, as always, about victims' rights and some of the fantastic work that is being done by some countries in the region, like the Philippines, with the victim witness coordinator, etc. So it remains to be said that there is still much to be done. There is definitely good work that has happened and that we need to really build upon. But at the same time, this is not a time to be complacent. And I think if the last few months have taught us anything, is that it is a good time to press reset and to rethink how we do things. So with that, I'd really like to say a big thank you to all my panelists. It's been an absolute treat to be moderating you today. And thank you to USAID and to Winrock International for hosting us. Thank you very much.
Thank you very much.
Thank you.
Thank you everyone for attending
Thanks.
the Evidence to Action Summit and today's session. Please do join us at other sessions in the summit, and you can find the links to the next sessions in your participants guide sent to you by email. I do want to note that we have 2 working sessions today where they will be highly interactive. We will be using breakout rooms on Zoom. So please do check out the descriptions in your participants guide if you would like to attend. I'm pasting into the chat right now some recommended pre-reading for tonight's working session. So if you'd like to attend that with Juliana, then please go ahead and check out that link in the chat. But the session happening in just 2.5 hours from now is about worker technologies, and they will both be very, very interesting. So please continue the conversation in the conference community on MS Teams, especially if you're interested in finding collaborators for the pitch competition being offered through participation in the Evidence to Action Summit. Thank you again for your participation and have a wonderful day.